If your employment has recently been terminated, you may be wondering whether or not you've been wrongfully dismissed. Hi, I'm Mike from Cashion Legal, and in this video, I'm going to cover the topic of what is wrongful dismissal. At the end of this video, you'll have a better understanding about whether or not you have been wrongfully dismissed and what your remedies might be in your situation. At the beginning of this video, I want to dispel a very common misconception about wrongful dismissal. Wrongful dismissal does not necessarily refer to the circumstances under which your employment was terminated, and it doesn't mean that your employment was terminated for a bad reason. In Canada, wrongful dismissal specifically refers to any situation where your employment is dismissed without sufficient notice or pay in lieu of notice. At law, employers have various obligations to provide employees with notice or pay in lieu of notice, and when someone is wrongfully dismissed, that means the employer hasn't fulfilled that obligation. Sometimes people will contact our office and talk about the circumstances of their dismissal and talk about the merits of their employer's decision to terminate their employment. The reality is that in most circumstances, those considerations are not important for answering the question about whether or not you were wrongfully dismissed. Wrongful dismissal is almost always focused on that one question about whether you receive adequate notice or pay in lieu of notice. So if your employer has not provided you with advance notice of the termination of your employment, and they're providing you with notice that is less than what you think you are entitled to, you may have been wrongfully dismissed. So in order to understand whether or not you have been wrongfully dismissed, it's important to understand your employer's obligation to provide you with notice. At law, employers have various obligations to provide employees with notice or pay in lieu of notice in connection with termination of employment. In Alberta, there are three sources of your entitlement to notice or pay in lieu of notice. The first source of that entitlement is Alberta's Employment Standards Code. This is a piece of legislation that governs basic rights between employers and employees throughout the province of Alberta. The Employment Standards Code sets minimum requirements that employers are required to satisfy to provide notice or pay in lieu of notice on termination of employment. The second source of entitlement to notice or pay in lieu of notice is your employment contract. If you have a written employment contract with your employer, it may have language dealing with your entitlement to notice or pay in lieu of notice. This entitlement can be greater than the minimum set by the Employment Standards Code, but it cannot be less than these minimums. The third source of your entitlement to notice or pay in lieu of notice is the common law. If you do not have a written employment contract with your employer, or if your employment contract doesn't address your entitlement to notice or pay in lieu of notice, then you are likely entitled to common law notice. Also called a reasonable notice, common law notice is not a fixed calculation. There's no hard and fast rule that you're entitled to, for example, 1 month per year of service. In fact, it's determined by the courts with reference to a variety of different factors, including age, length of service, your position with your former employer, and the availability of alternate comparable employment. Because there is no hard and fast rule about how to calculate common law notice, most wrongful dismissal disputes are focused on how much common law notice an employee is entitled to. I want to get something out of the way because I keep talking about notice or pay in lieu of notice. Just so you know, what we commonly refer to as severance in Alberta is actually pay in lieu of notice. This means that your employer is providing you with the compensation that you would have received had you been able to work through your notice period. So regardless of whether your notice entitlement is established by the Employment Standards Code, your employment contract, or the common law, your employer is required to provide you with whatever compensation you would have received had you been able to work through that notice period. There are some qualifications to that, and there are certain circumstances where your employer isn't required to provide certain forms of compensation during your notice period, but ultimately that is the general principle. Bringing this back to this topic of wrongful dismissal, this means that your employer did not adhere to one of these obligations to provide you with notice or pay in lieu of notice in connection with the termination of your employment. So, for example, if you were entitled to 6 weeks of notice under the Employment Standards Code and your employer terminated you without any notice and without any compensation, you would have been wrongfully dismissed. Or for another example, if you're entitled to 12 months of common law notice and your employer only provided you with 6 months of working notice but did not provide you with any compensation, in that situation you would also have been wrongfully dismissed. There is one major caveat that I should get out of the way, because everything I've just talked about is applicable to situations where your employment has been terminated without cause. If your employment is terminated without cause, your employer is required to adhere to your right to notice or pay in lieu of notice. So you can expect to receive some level of compensation from your employer in these circumstances. However, if your employment is terminated with cause, you are not entitled to any notice or pay in lieu of notice. Employment can be terminated with cause if you've engaged in some type of misconduct that is fundamentally incompatible with your employment relationship. Some common examples of conduct that justifies termination for cause include theft, dishonesty, or criminal conduct in the workplace. If your employer has just cause to terminate your employment, then you are not entitled to any notice or severance in connection with the termination of your employment. However, just because your employer has alleged that they have just cause does not mean that they actually have just cause to terminate your employment. In fact, there are some employers who will attempt to terminate your employment for just cause, even though they don't have the right to do so in order to avoid paying you severance. If your employer has alleged just cause in connection with the termination of your employment, we strongly encourage you to seek legal advice, which you can do by clicking the link to our website in the description of this video. Another qualification that I want to add to this analysis are the issues of aggravated and punitive damages. While most wrongful dismissal claims are principally focused on the employee's entitlement to pay in lieu of notice, there are some extreme examples that are focused on other types of damages, specifically aggravated damages and punitive damages. Aggravated damages can be awarded in any situation where the employer engages in conduct that is harsh, misleading, or unduly insensitive during the termination process. If the employer has done this, the court can award additional damages against the employer that are on top of the normal severance entitlements. It's worth noting that in order to be entitled to aggravated damages, the impugned conduct must be connected to the termination process itself. So if you were subject to a toxic work environment, but that wasn't connected to the actual termination of your employment, it's unlikely that you can claim aggravated damages in this circumstance. The other type of damages that are even more rare are punitive damages. Punitive damages are only awarded where the employer engages in extreme conduct and the court wants to denounce that conduct through a penalty. Both aggravated damages and punitive damages are relatively rare and not applicable in most wrongful dismissal cases. Another major consideration of wrongful dismissal claims is your obligation to mitigate your damages. If you're carrying out a wrongful dismissal claim against your former employer, you have an obligation to mitigate your damages, which means you must make reasonable efforts to search for alternate comparable employment. If the court finds that you did not take reasonable steps to mitigate your damages, this can reduce the amount that you can claim against your former employer. Similarly, if you do obtain alternate employment during your notice period, any amounts you earned through this new employment can be used to reduce the amount you can claim against your former employer. This duty to mitigate has a significant impact on negotiations with your former employer and should always be factored when considering the reasonableness of any offer put forward by your former employer. Another thing that's worth clarifying is that in Alberta, wrongful dismissal claims do not directly deal with issues of discrimination. In Alberta, complaints for discrimination are the exclusive purview of the Alberta Human Rights Commission. So if your employer has engaged in discriminatory conduct in connection with your termination, you may need to file a human rights complaint in order to seek redress for that conduct. There is sometimes overlap between these two bodies of law, being discrimination and wrongful dismissal, but they are not technically the same thing. So what should you do if you think that you have been wrongfully dismissed? My first piece of advice is this: if your employment has been terminated by your employer, and you're wondering whether or not you've been wrongfully dismissed, the first step is to determine your notice entitlement. This always starts with a review of your employment contract, because your employment contract might contain language impacting your entitlement to notice or pay in lieu of notice. If you do not have a written employment contract with your employer, or if your employment contract is silent on your entitlement to notice or pay in lieu of notice, then you're likely entitled to common law notice. Conversely, if your employment contract contains language limiting your entitlement to notice, this may set the bar for what you're able to claim against your former employer. However, the courts in Alberta have been very firm that clear and unambiguous language is required in order to limit an employee's right to notice or pay in lieu of notice. For that reason, if you do have a clause in your employment contract which limits these rights, we encourage you to seek legal advice about the enforceability of this language. The second piece of advice I have for you if you've been wrongfully dismissed is to not sign anything until you have considered whether the offer is fair. Once you sign a release in favor of your employer, it is very difficult to set aside the terms of that release. So if you're interested in pursuing a claim against your employer for wrongful dismissal, you shouldn't sign the release until you've actually assessed your rights. My third piece of advice is to be mindful of your obligation to mitigate your damages. If you decide not to make any efforts to search for alternate comparable employment during your reasonable notice period, this can be held against you. If you do not apply for any jobs, this may significantly reduce the amount that you can claim against your former employer. Similarly, if you have a job offer that's forthcoming and you know that you're going to be reemployed in the near future, this may incentivize you to accept an offer from your employer even if it doesn't align with your best day in court. The bottom line is that wrongful dismissal does not necessarily refer to a termination that is handled poorly or done for the wrong reasons. It primarily refers to the issue of whether you receive adequate notice or compensation in connection with the termination of your employment. The analysis of whether you've been wrongfully dismissed starts with a review of your employment contract to see if the termination process aligns with those obligations. If you've recently lost your employment and you're wondering whether or not you've been wrongfully dismissed, we can assist you with this. Our team provides terminated employees with clarity about their circumstances, strategies for negotiating their severance packages, and peace of mind through sound advice and strong representation. If you're looking to connect with our team for assistance, you can click the link to our website in the description of this video and book a consultation with our office today.